This is College Matters from the Chronicle.
As a practical matter, if they strike a deal and they get what they want, it sort of doesn't matter whether it was legal or not. But as a matter of principle, it certainly does.
In the first year of Donald Trump's presidency, university leaders have gotten a crash course in self-defense. Citing concerns about antisemitism and unchecked liberalism on college campuses, the Trump administration has clawed back or frozen hundreds of millions of dollars in research funding at numerous highly selective universities. From there, the playbook looks familiar. Force universities to the bargaining table, extract some political concessions, and collect for the government millions of dollars in fines. All of this is putting higher ed leaders on their heels as they weigh the risks of fighting back against the consequences of cutting deals. A version of this saga is unfolding now at the University of California at Los Angeles. But wait a minute, can the government really do this? Is this even legal? Those are the questions we'll dive into today with my colleague Katie Mangan, a senior writer at the Chronicle of Higher Education, and Peter Elkind, a national investigative reporter at ProPublica. Katie and Peter recently co-wrote a deeply reported article about the Trump administration's tactics at UCLA. Katie's written extensively about campus diversity issues, student activism, and the political backlash against both. And Peter is an author or co-author of 3 books, including The Smartest Guys in the Room, The Amazing Rise and Scandalous Fall of Enron, which is also a fantastic documentary. Katie, Peter, welcome to the show.
Thanks for having me.
Good to be here, Jack.
So, Katie, let's start with you. The Trump administration has aggressively pursued settlements with a number of colleges, including Harvard University. What were you hoping to learn about its pressure campaign against UCLA?
UCLA is a big target in a blue state, and the consequences of freezing hundreds of millions of dollars in research funding there are immense. It's part of one of the nation's largest and most prestigious public university systems, with 10 campuses and nearly 300,000 students. We wanted to use UCLA as a case study to examine how the Trump administration was picking its targets and justifying some draconian penalties and demands even before a full investigation had been completed. The investigations are being carried out in the name of cracking down on antisemitism, but the remedies the administration is demanding go way beyond that to include changes in admissions policies, to treatment of transgender students, to hiring. So it's important to understand what these universities are up against and how these levers of power are being pulled behind the scenes.
Right. So huge implications to how these negotiations unfold. You got under the hood of what really happens behind the scenes, which is what I love about this reporting. Peter, give us a little context for this discussion, though. Where does this story begin in your mind?
Sure. Well, I think it really begins with the election of Donald Trump as president. Almost immediately after taking office, he staffed the top levels of the Department of Justice with folks who are really hell-bent on remaking higher education and using civil rights laws in an extraordinary way to bend universities to their will. Our reporting shows that shortly after the Trump team took office, career civil rights lawyers were dispatched to California to investigate multiple UC schools with marching orders, basically to find evidence to support a preordained conclusion that they, or and in particular UCLA, had illegally tolerated anti-Semitism.
So let's pause on something you said there, Peter. You mentioned a preordained conclusion. So the DOJ lawyers were tasked with finding evidence to support what was already a predetermined outcome. Is that what you're saying? And help me understand the significance of that.
Yeah, that is what I'm saying. And it's based on what the DOJ lawyers, career lawyers who were assigned to the case, who investigated the matter, told us. Normal process is you field a civil rights complaint. If it's serious enough, you investigate. You do your homework. You spend many months, and typically in a case like this, at least a year, to investigate the allegations and consider the law before you reach any determination about whether a civil rights complaint is really justified. In this case, from the very outset, Leo Terrell, who is the bombastic former Fox News commentator, who was appointed to a top DOJ civil rights post, including with responsibility for running the president's task force to combat anti-Semitism, he was on Fox News starting in early March, declaring, again, even before the investigation was really underway, that the entire UC system was guilty of anti-Semitism. And he was declaring he was going to sue, bankrupt, and take away every single dollar from these schools. That's not the way it's supposed to work.
So this is a person who's at the very center, to some degree, of the Trump administration's anti-Semitism program, and he's calling the verdict well before the jury's been assembled.
That's exactly right. And then we also had multiple sources who told us, as they were sent out to try to investigate the matter, they were expected and pressured heavily from the start to come up with a justification for bringing an anti-Semitism complaint. They literally told us, quote, the end goal was to file a damn complaint or have something to threaten the university. They were instructed, you have 1 month to find evidence of anti-Semitism.
I mean, I know you and Katie are good at getting people to talk, but were you surprised, Peter, that some of these current and former lawyers for the Trump administration spoke with you so candidly?
We were. I mean, I think what motivated them is that they were horrified. They found this very disturbing. These are folks that had worked through multiple administrations, Democratic and Republican, in some cases for decades, and they were finding the Justice Department turned in ways that they couldn't stomach, and ultimately virtually all of them have left.
Now, we've heard a lot of complaints that the Trump administration has weaponized the DOJ to go after any number of enemies, including the universities, for ideological reasons. Universities obviously don't like having their federal funds frozen or clawed back. But let's zero in on what strikes me as the biggest question about the administration's tactics here. Is this normal? Is it appropriate? And ultimately, is it legal?
Well, I'm not a lawyer. I'm married to one, but I did speak to a lot of lawyers. We did speak to a lot of lawyers who know a lot about this. And they said this was not normal. And they also said it was not legal. The normal process in investigating and trying to address a civil rights problem and anti-Semitism as well is that you're trying to make things better. You're trying to figure out whether there has been first of all, the law isn't about whether anti-Semitism has taken place on your campus. It's whether the employer has engaged in a pattern and practice of tolerating anti-Semitism. That's really the issue. And the redress is supposed to be taking steps to keep it from happening again and keep the harm from taking place, not punishing the institution.
So critics could be right that in the wake of the war in Gaza and the encampments that popped up on various university campuses like UCLA, that anti-Semitism was a problem, even a rampant problem. But if the university takes steps to address this and shows a seriousness of purpose around that, it probably is not a violation of the law. Is that your understanding, Peter?
Yes, that's right. And it depends on what the university has done to try to deal with it. At UCLA, there was an anti-Semitism issue, and I think they would acknowledge there are issues they're still combating now, but they have taken a lot of steps, and that raises the issue of whether there's a justification for bringing a civil rights suit now,
right,
and caused lots of pause and concerns about bringing this action and about these findings from the lawyers who were investigating.
And I know I spoke there in some generalities, Peter. Each case is different and would have to be looked at under a microscope, but I appreciate you giving us that broader understanding of what civil rights laws show. So, Katie, it sounds like these tactics to some degree rest on dubious legality. We've seen similarly situated universities, notably Harvard, sue over the Trump administration's efforts to claw back research funding, citing anti-Semitism. Why hasn't UCLA done that?
Well, the UC system is negotiating with the administration and has not sued, which is disappointing some faculty and labor groups who've taken it upon themselves to launch their own legal battle. California Governor Gavin Newsom has called the demands extortion, and he's threatened to sue the Trump administration. But the UC system relies very heavily on federal funds for about a third of its revenue, and they don't feel like they can risk that. Even though UCLA is the initial target, the Trump administration has threatened to bring similar actions against some of the other 9 campuses. When Harvard sued, the backlash was immediate, so there's a lot at stake. In the short run, though, that, of course, is making things very hard for researchers.
Yeah. And so UCLA is taking, at least for now, a more conciliatory approach. And I think one of the people responsible for that, we should mention, is James Milliken. He's the president of the UC system. Peter, you had a chance to talk with him. Tell us about Milliken and where he fits into this story.
Yeah, J.B. Milliken is a veteran university system administrator. And he literally sort of walked into this new job, which was the pinnacle of his long career, in the midst of this chaos. Milliken was playing golf in western Nebraska in the days right before he was supposed to take over the reins of the UC system. And that's when he got the first news of the Trump administration cutting hundreds of millions of dollars in research funding on the golf course. He immediately departed, drove to the nearest airport, which was 5 hours away, jumped on a plane to California, and dove into trying to deal with this problem. Milliken's a very pragmatic guy, a very able operator, a former Wall Street lawyer. He had successfully run big college systems in blue states and red states. First, it was the City University of New York, and then the University of Texas, before he came to the UC system. And now he's dealing with this entire mess.
Yeah, and it sounds like it really caught him at an inopportune moment. Real baptism by fire for Milliken. He wants a settlement. Others are trying to go to court, though. Katie, you mentioned this earlier. Tell us about that.
The American Association of University Professors brought its own complaint, challenging Trump's targeting of UCLA and other UC campuses, and their legal arguments are resonating. In November, a federal judge sided with the AAUP. She issued a scathing preliminary opinion against the Trump administration. U.S. District Judge Rita Lynn said the actions against UCLA had flouted legal requirements, and she ordered it to seize all of what she called coercive and retaliatory conduct against the UC system. She wrote that the administration's playbook illegally used civil rights investigations and funding cuts as a way of, quote, bringing universities to their knees and forcing them to change their ideological tune. Most of UCLA's frozen funding has been restored by now, but there's still a real question about how many new grants are going to be improved.
So just to further clarify, Katie, what laws is Judge Lynn saying have probably been broken here?
Her ruling describes an undisputed record of constitutional breaches of the First and 10th Amendments. So essentially, we're talking about violations of free speech and acts of federal overreach. The ruling says that UC faculty and staff are afraid to teach or research topics that the government might consider woke or leftist, which the judge says are classic, predictable First Amendment harms. The ruling also says that these funds have been withheld without any respect to the procedural requirements under Title VI and Title IX. So there are serious violations of due process, according to this ruling.
Wow. So, Peter, that's a pretty stinging rebuke from this judge.
Yes, it is.
In terms of the tactics. At the same time, I feel like anybody who's watched Trump 2.0 has seen that this administration, in a lot of areas, including higher ed, will throw spaghetti at the wall and see what sticks. And it feels like that's part of the strategy here. If a place like UCLA strikes a deal, does it matter if the tactics they use to get there were strictly legal?
Well, no, that's a really interesting question. And you're right. It's very consistent with the playbook the administration's using on multiple fronts. You know, as a practical matter, if they strike a deal and they get what they want, it sort of doesn't matter whether it was legal or not. But as a matter of principle, it certainly does. You know, if you capitulate, as universities have, as some law firms have, it shows that the pressure tactics work. Even if judges have weighed this, ruled that there's no basis for the actions and demands that the administration is making. It doesn't show that if it works, it doesn't show that they're legal or okay. And that's why so many people at the UC system really want them to resist any kind of deal.
Stick around. We'll be back in a minute.
Hi, I'm Fernanda Zamudio Suarez, a producer at College Matters. If you're enjoying the show and want to support us, I hope that you'll follow on Apple Podcasts, Spotify, or wherever you get your podcast. You can also leave us a review or invite a friend to listen. At College Matters from the Chronicle, we want to give listeners like you insightful audio journalism about higher education that you won't find anywhere else. By subscribing and spreading the word, you'll help us do just that. Thanks so much for listening.
I am curious what the Trump administration or people who support them say. Katie, what does your reporting tell you about that?
The government lawyers have acknowledged that they haven't followed established civil rights procedures. They've described a hodgepodge, that's word one Department of Justice attorney actually used, a hodgepodge of actions being taken by several different agencies. The point they're making is that if a university's programs don't line up with the president's policy priorities, they have a right to cut funding. And supporters of the administration's approach will argue that anti-Semitism is such a bad problem that aggressive action is warranted, even if it violates traditional notions of due process. Kenneth Marcus, who is an anti-Semitism watchdog and a former Assistant Secretary of Education for Civil Rights under Trump, is one who makes that case.
So, Peter, I want to go back to something you said earlier. You said that you thought that people spoke to you in part because they were outraged by this, people who worked on these cases. I'm curious if you can tell me a little bit more about that. How do the government officials who were assigned to the UCLA case describe it to you?
Well, they described it as unlike, these are government officials, government lawyers who were investigating employment discrimination, anti-Semitism. They described it as unlike any case they had ever worked on and any civil rights matter they had ever dealt with in terms of the amount of pressure they were under to come up with findings, preordained findings in a very rapid pace. As I mentioned
this
before.
was very fast, right, relative to the types of investigations they normally do?
Oh, yeah. They describe, they said a case which involves, initially was looking into multiple universities, multiple campuses, and really tricky questions of law and the First Amendment. They said normally this would take a year or more, and that they were literally being asked, well, have you found evidence to justify a complaint 2 or 3 or 4 weeks in? Ultimately, they had about 3 months before they felt like they had to present a case, a memo recommending a complaint. And that they focused, after looking at 4 different universities, they focused on UCLA because that's where they found the strongest evidence of anti-Semitism. They felt that 3 other campuses they were directed to investigate, there just wasn't a basis for bringing a case. But even with UCLA, they felt like there wasn't strong evidence. And we obtained a 47-page memo where they detailed sort of play-by-play of what they had looked at, what they had found. And they noted that there just wasn't strong evidence, even in the case of UCLA, for the kind of harassment that had taken place earlier, and that UCLA had taken a lot of steps to try to deal with it. So several people who worked on the investigation literally told us they were glad they would soon be gone, and they wouldn't have to put their own names on this complaint.
And you mentioned pressure coming from various quarters. You mentioned Leo Terrell earlier. Who was pushing them to expedite this investigation, reach a preordained conclusion?
Sure. It was, generally speaking, the group that they speak of as being the politicals. And this is true of any administration, that at the top levels, the higher levels, and the very top levels in the Justice Department, the administration appoints people. Obviously, it's generally people that are respected and viewed well by the president and his attorney general. They also, in this case, had a strong support for the administration's agenda, and in this case, an ideological agenda.
So you have political appointees really pushing these career lawyers to reach a predetermined outcome.
That's exactly right.
Well, let's talk a little bit about the Civil Rights Division of the Department of Justice. Talk to me about what it normally does, what's taken shape under the Trump administration. I know a number of people have left this unit. Does that have larger implications beyond UCLA in your view?
It does have larger implications. There's been a wholesale exodus from the Civil Rights Division, and it's people who departed on their own, who accepted deferred resignation programs. And the group that was investigating the University of California is an example of this. At the point they finally filed this memo recommending a case that they thought was shaky against UCLA, literally at the end of May, pretty much all of them were gone 2 days later and departed from the administration, departed from the Justice Department. And again, in many cases, people have been there for years, in some cases even decades. But it's also seen an abandonment, a significant shift from the mission of the Civil Rights Division, which historically had been involved fighting sex and race discrimination against disadvantaged groups. The division's morphed into much more of a political arm for carrying out a distinctly conservative political agenda, in their view.
And there are certainly people who would argue anti-Semitism is absolutely a civil rights concern, and the Department of Justice should be concerned about this. I'm curious, Katie, have you talked to victims of anti-Semitism on these campuses, on UCLA's campus in particular? What do they think about the Trump administration's approach here?
We definitely found people on all sides of the issue, but it's interesting to hear the take from Ron Avi-Astor. He's a professor of social welfare and education at UCLA. His complaints about anti-Semitism were highlighted in the government's case against UCLA, but even he told us he was horrified to see them being used to justify massive cuts to research funding. He told me he felt like he was being used and that the government's approach was making the very real ongoing problem of anti-Semitism worse, not better.
So, Peter, this reporting that you and Katie did really takes us inside the Trump playbook, if you will. What did you learn about it?
Well, one thing that came across dramatically was that a lot of what they've done and are trying to do has really very little to do with actually fighting anti-Semitism. And there's a strong feeling among advocates, many advocates on campus for Jewish groups, for people who are actually victims of anti-Semitism, that the actions that are being threatened and taken, demanding a $1 billion fine from the University of California at Los Angeles, cutting off hundreds of millions of dollars in research funding for cancer and other kinds of research, does absolutely nothing to fight anti-Semitism, and in fact creates a backlash against Jews on campus and makes things worse. It's striking how this played out and how evident it became as we dug into the investigation and the way it was addressed in campus.
And there's some history here that I think is important. In the waning days of the Biden administration, UCLA actually reached a settlement with the government, right, over these charges of anti-Semitism. Can you talk about that and how that fits into this larger story?
Sure. In December 2024, the University of California system reached a resolution agreement with the Department of Education, resolving a lot of the anti-Semitism complaints that have been brought up to that point. It called for a number of steps, including moving in on protests earlier when harassing or illegal behavior occurs. The university also committed to investigate both anti-Semitism and anti-Palestinian complaints more thoroughly. One of the things that we heard from Catherine Lehman, who was the chief civil rights officer during the Biden administration, was that the Trump administration didn't acknowledge any of this in its most recent demands. She said the administration didn't show any justification for making further demands when the university had already agreed to take these steps and was in the process of doing so.
I mean, one of the things that was really striking here is that the career lawyers spoke about was that they're literally beginning new investigations of matters that had already been investigated and were subject to settlements with government oversight by the Department of Education. And here they were opening brand new investigations over the same matters despite substantial progress that had taken place already.
Is this what we might call double jeopardy, Peter?
You could think about it that way. Absolutely.
Okay.
That's certainly the way the civil rights folks felt, that we would never have brought this case. We would never have reopened an investigation like this. That's what a number of them told us.
So, Peter, in court, this might be what you call bad facts. You have an investigation with a predetermined outcome. You have an investigation of issues that have already been settled with the federal government. You have a federal judge saying this is BS. Is the Trump administration at all chastened by any of these developments, to your knowledge?
It doesn't seem to be so. They haven't withdrawn complaints or dropped matters. On the other hand, they haven't upped the ante further. And that's part of the thinking on the part of the UC administration, that they didn't want to file a suit and challenge them directly out of fear that they would bring new cases and make more threats against the university and take more action to cut off funding.
One of the reasons I wanted to have this conversation is I have had back-channel conversations with people in college leadership who said, somebody needs to talk about the legality of this approach or the dubious legality therein. And I think your reporting does an excellent job of laying out those questions. I am curious where we go from here, though. Based on what you've learned, you've unlocked so much about how the Trump administration operates. Katie, what do you think we should take away from this? If you're invested in the future of higher education in this country, what does this reporting tell you?
One of the things I walked away realizing was just how vulnerable most colleges are to threats coming from the federal government, and how even if the penalties the administration is imposing violate traditional standards and even laws, it sometimes doesn't seem to matter. The administration is exploiting that vulnerability, and it's doing so effectively. Time and time again, its tactics are shot down in court. Two federal judges on the East Coast and the West Coast have said this is illegal, but the cases are appealed and they drag on for months. By then, the damage has been done. Colleges have preemptively cut programs that it knows the Trump administration doesn't like. And researchers whose work was frozen midstream are questioning whether they can remain in academe. It's a problem with no easy solution. So two things can be true at once. The Trump administration is employing tactics of very dubious legality, and they're getting called out for it in court. But they're also getting a lot of what they want because they've effectively exploited universities' reliance on federal money.
It's a stunning time that we're in when things that appear questionable, to put it mildly, legally, appear to be a pretext, are proving very effective in many cases for the Trump administration getting what it wants.
And having a real profound effect on higher education and its trajectory. Thank you so much for coming. Thank you so much for your reporting. I really appreciate it.
Enjoy the conversation, Jack. Thanks for having us.
Likewise. Thank you.
College Matters from the Chronicle is a production of the Chronicle of Higher Education, the nation's leading independent newsroom covering colleges. If you like the show, please leave us a review or invite a friend to listen. And remember to subscribe on Apple Podcasts, Spotify, or wherever you get your podcast so that you never miss an episode. You can find an archive of every episode, all of our show notes, and much more at chronicle.com/College Matters. If you like, drop us a note at collegematters@chronicle.com. We are produced by Rococo Punch. Our Chronicle producer is Fernanda Zamudio Suarez. Our podcast artwork is by Cottrell Thomas. Special thanks to our colleagues Brock Reed, Sarah Brown, Carmen Mendoza, Ron Coddington, Joshua Hatch, and all of the people at the Chronicle who make this show possible. I'm Jack Stripling. Thanks for listening.